let's get started. So again, thank you for joining us today. My name is Brian Tully of Tully Law Group. What we do every day of the week is help our clients protect the most assets possible and help them get the best care possible, all right? And what we're going to be talking about today is a little bit exciting, a little bit technical at times, but it is the power of attorney. And it's not just generally talking about it, it is the fact that New York State has signed and will be implementing a new, what we call statutory short form. Okay, what that means is the New York State legislature amended the statute, the governor signed it, so it is a statutory form power of attorney, just like we've had and implemented the same way, but now it's a little bit different, and that's what we're here to talk about today, the new statutory form. Okay, so I am going to assume that you can still hear and see me, which is good, and see the PowerPoint. Now let's get started. So by way of introduction, I always like to do that. I don't jump right into things. I like to lead up to it. We have a lot of people on today's webinar, so I want to make sure that those new folks know exactly what we're talking about today. So first and foremost, what exactly is a power of attorney? And I often say it's the most important, one of the most important documents out there, but it is just a tool. It is a tool that allows you to appoint somebody to help you with your legal, your financial, and your personal affairs. It is crucial in that if it doesn't exist, and I'll be talking about this, if there is no power of attorney, then who handles your legal, your financial, and your personal affairs, okay? So that's why it's very important. It is not for healthcare decision-making. It is just the legal and the financial and the personal affairs. If you need somebody for healthcare decision-making, as all clients do, that's in New York, what we call a healthcare proxy, all right? Power of attorney finances generally, healthcare proxy for healthcare decisions. Within a power of attorney, you have different people. You have what's called a principal, that is the creator of the power of attorney document, the signer, if you will. And you have an agent, and you should have a successor agent. That's the person you're appointing to handle your financial, legal, and personal affairs, okay? So it's a tool geared toward these items. Now, there are different versions of powers of attorney, and the new law will carry this over. There's what's called a general power of attorney. There is a durable power of attorney and a springing power of attorney. General power of attorney is if you just need somebody to go to a real estate closing for you. It's simple, it's limited duration. You're gonna have capacity. You're not expected to lose capacity during the day that this is happening. So a general is the most simplest form. We never use those. The ones that we use every single day of the week is the durable power of attorney. We don't use springing that much either. Durable, however, first and foremost, is where there's language in the power of attorney that states very clearly that the power of attorney remains valid even if the principal were to lose capacity. Centuries ago, when the whole idea of agency was created, before it evolved into a power of attorney document, you could send somebody to handle your business. But if the person, the principal, were to lose capacity, turn ill, or mental capacity or something occurred, if I could no longer make the decision, well, then my agent can no longer make the decision. And that was troublesome. So the idea of durability, meaning that the power of attorney remains valid, the agent can still act even if I, as the principal, no longer have the ability to, was introduced, and it is what is required when you're talking about powers of attorney and estate planning or elder care law, elder law issues. 100% durable power of attorney is the way to go. Springing, on the other hand, not so much. A power of attorney in general, not to use all these same words, but a power of attorney in general is effective the moment it's signed, and that's generally a good thing. The springing aspect means that it wouldn't be effective immediately. It means that it would actually only spring into being if certain conditions were met, such as two doctors certifying that the principal can no longer handle their legal or financial affairs. Those are some hoops for an agent to jump through when in fact they should probably be helping the principal and taking care of his or her affairs. So we don't like the springing because it can cause delays, and perhaps the doctor isn't willing to sign that form. And it can prevent the use of the power of attorney in general in the extreme case. The bottom line is if a parent is picking their two children to be the power of attorney agents in the future, that means you're going to trust them then. So our recommendation is really consider trusting them now. All right. In addition, you don't really have to give them the power of attorney form. They don't have to have that document. You can keep it someplace safe within your home. We don't like safe deposit boxes. So you keep it someplace safe at home. And if they don't have it, they can't use it. Okay. So to finish up this slide, we always do the durable power of attorney, not the general, and not so much the springing. Why is a power of attorney so important? Well, to put it politely, stuff happens. All right. It's if you look back over the last year, if you look at family situations, if you look at illnesses, you look at incapacity, you look at dementia, there are things that happen in our lives. And if something like that were to occur, where there is some type of a trauma or illness, and you're no longer able to handle your financial and legal matters, or if there is a decline in capacity, short-term memory loss, dementias, Alzheimer's, related to Parkinson's, there are a number of medical conditions that can actually lower and decrease the capacity, your ability to handle your own affairs. If those things were to happen, then what? If you're not able to handle your affairs because of a trauma or an illness, or you're not able to handle your affairs because of a mental decline, then who does it for you? Okay, that's what this is about. Now, there are, in fact, two ways to address this. The first way is to plan in advance, and that is probably the most common theme when I talk to folks. Get your planning, get your protection done in advance. Now, some have said back to me, well, how am I going to know when that is? What's advance? It's as soon as possible. It's as early as possible, because we don't know what tomorrow holds for any of us, okay? So the idea of planning in advance is sitting with myself, my team, somebody like us, and getting your estate plan in place. And if you're of a certain age or health condition, maybe you're looking at asset protection, okay? So getting it done in advance is the preferred, 100% the preferred method of handling it. With that said, crises occur. And what that means is if there is no power of attorney in place and capacity is lost, now what? Well, you're going to be forced into what's called a guardianship proceeding. If you did not plan in advance and have a power of attorney done in advance, or if you do have a power of attorney and it's not sufficient, and we see a lot of those. Every week we're seeing a power of attorney that is not the appropriate power of attorney for aging. It's not the right estate planning power of attorney. Perhaps it's not durable. Perhaps it's not made comprehensive to cover everything that can occur: asset protection, income protection, Medicaid applications. Therefore, if it doesn't exist, or it's insufficient and capacity is lost, then a guardianship proceeding will probably be required. And some of you may be hearing that for the first time. In other states, they call it a conservatorship. So let me talk about this briefly for a moment. And again, this is if there is no power of attorney, or the power of attorney you have is insufficient, okay? A guardianship proceeding is an adversarial court proceeding. This is not where everybody gets along and decides to do what's best. This is where a petition is brought, in order to show cause is brought to a judge in the county where the alleged incapacitated person resides. That alleged incapacitated person would literally have to be declared incompetent. Not a pleasant, delightful process if you're dealing with your loved one. It's where the rights and the abilities of that person to handle their own financial and personal decision-making is stripped from them. And those powers are given to somebody else, usually a family member, but it could be an outsider as well. Bottom line is you want to avoid all of this. A guardianship a judge can appoint a guardian over the person, or a guardian or a guardian over the property. Guardian over the person is to make healthcare decisions. Guardian of the property is like the power of attorney. It's to handle your financial and legal affairs, okay? It's not a simple proceeding. I'm trying to share that as strongly as I can. You could have upwards of 3, 4 attorneys involved. And what do attorneys do? Usually they bill, and typically they bill by the hour. You're going to have an attorney for the petitioner, the person asking for the guardianship. The court can appoint an attorney over your loved one, over the alleged incapacitated person. You can have a child or a sibling say, you know what, you shouldn't be the guardian, I should be. That person will have their own attorney. And finally, the court is going to appoint typically an attorney to act as a court evaluator. That is an attorney that will typically interview the different parties, create a written report, and go back to the judge and say, this is my recommendations. It could be up to 4 attorneys. There are significant costs in a guardianship, especially when you compare it to a legal document like a power of attorney. A straightforward, uncontested, unchallenged guardianship proceeding can be upwards of $5,000 to $10,000. If it's contested, where you have different parties saying, I should be it or I should be it, you could be at $20,000, $30,000, $40,000. It's litigation, okay? It's not overnight either. There is a significant time commitment when it comes to bringing a guardianship proceeding, and it's not completed until a good 6, 8, or 10 months down the road, okay? All of this stuff can be avoided with, again, the appropriate and sufficient comprehensive power of attorney, okay? So what are you going to do? You're going to get yourself a plan with a good, sufficient, solid, comprehensive power of attorney if you don't have one already. So the current power of attorney, now again, this is coming to an end, okay? June, next month, is when the new form is going to be implemented. It's going to be released, and that is what the effective date, and I'll get to that in a slide or two. So the current power of attorney, it's what we've been utilizing since 2009 and 2010. The complexity and the problems, if you will, with the current power of attorney form is right there. It's summarized right there. It was created in 2009, but because it was so complex, it already had to be amended once in 2010. So the form we're using is a 2010 form. One of the main complexities and complications of the current power of attorney form, not the new, the current, is that it's broken into 2 parts. You have the main form, which is what you'll typically see, the letters A through P, for example, but you also have what's called the statutory gift rider. That is perhaps one of the more complicated parts of the current form. It's a separate rider. It has to be signed at the same time. There's modifications for both of these parts that literally you want to throw the kitchen sink in there to cover as much asset protection, income protection, Medicaid work, Medicare issues, tax issues, trust issues. All those modifications have to be built in there. And that, by the way, is where most people make the mistake of not having the right form. They're lacking the right modifications, okay? And there's your modifications there. So bottom line is the current form is complicated. It's complex. It's been called overly burdensome. The principal has to sign in multiple places, initial in multiple places. Imagine in my line of work with our elder care clientele, or picture your elderly loved one. It's complicated. The initials, the signing, understanding what they're signing, it's been too much. So this new form that's being implemented and the simplicity we're hearing about is a very warm welcome, okay? Other complications, the first part is to be notarized. The gift writer has to be witnessed and notarized. The execution was always complicated. The current form forced what's called strict compliance. You couldn't delete a paragraph. You had to leave paragraphs even if they weren't pertinent to the situation. If there was a typo, you literally were supposed to leave the typo in the form. Also, the form was able to be rejected without any reason. Banks and financial institutions historically like to reject powers of attorney. They don't want the liability. So they would just reject it, and they would say, no, use our form. Making clients and their agents, their loved ones, jump through hoops for years, okay? That's where we've been, all right? Now, the new power of attorney statutory short form is going to be effective, as I said, June. It's going to be June 13th of 2001. So we're looking at about 5 weeks from now. Let me give you the bullet points. All right. So I'm going to list off, I think it's about 10 of the pertinent issues that the new form will encapsulate. All right. First and foremost, the new power of attorney law states that existing powers of attorney remain effective. Okay. So if you have a power of attorney from us from 2010, 2008, 1998, when we did them, definitely time to update and review, that's for sure. But if you have the old ones, as long as they were done properly, they are still effective. Okay. Another point, the new statutory short form power of attorney is most certainly more user-friendly. It's one document. There's no longer a statutory gift writer, okay? The great news is the complexities have diminished. We're going for simplicity with this new form, and we're grateful that it's coming out. Another point, the validity of the power of attorney is presumed. That was not the case, all right? We had to jump through hoops. We've had clients, my goodness, take the current power of attorney to banks and say, I'm not going to accept it unless your parent comes in with you, unless the principal's here. That defeats the entire purpose of a power of attorney because it's meant to send an agent to handle the principal's affairs. Not to mention if the principal themselves is incapacitated in the hospital, in a rehab center. During COVID, it was nightmarish at times because the bank would say, all right, we'll send the principal in and then we'll do it. They were so arbitrary and capricious that the fact that there is a presumption of validity and simplicity and other points I'm going to talk about is, again, we're very excited about it. If you can get excited about a legal document, I guess. Another point, not allowed in the current form. A lot of our clientele, as you could imagine, are going through not only perhaps capacity decline, but physical decline as well. And in this case, if there is a physical decline and they are unable to sign the power of attorney themselves physically, they have the mental capacity, just not the physical capacity, then another person can sign the power of attorney on your behalf. This is a great addition. 2 months ago, I was in a client's house, very difficult scenario, trying to have 90-year-old going through multiple issues, can barely hold the pen through initial after initial after initial after signature after signature. Very difficult and stressful for her, and we wish we didn't have to do that, but we did. Now that is alleviated. Now we don't have to worry about those issues, okay? So if there's another there at the direction of the principal with mental capacity, they can sign the power of attorney for them in their presence and at their direction, okay? Another good point, still have to look out for complications, still have to look out for potential fraud and abuse. And by the way, that was the main driver in creating the last round of forms. The legislature was very, very concerned about seniors and them being defrauded, being taken advantage of, financial abuse. That's why they took the great steps of creating this statutory gift writer where the principal knew exactly what can happen and can't happen. It was overkill and it's time for it to go, and it is going, but the intention was a good one. One thing that was kept is that if you are a potential gift recipient, gifting, by the way, is not just birthday gifts. In our world, gifting is asset protection. So if you're a potential gift recipient, you can't be a witness, and that makes sense. All right, it's a little too self-serving there. Okay, and by the way, if you have questions, I didn't say this in the beginning. If you have questions, you can put them in the box at any time. I will answer the chat box as well as the Q&A box once we're finished. In addition, we've been doing these webinars for a year. And if you ever want to know more about these powers of attorney, more about irrevocable trusts, more about Medicaid work, more about how we do what we do with our advocacy and our legal approach, all of those webinars over the last 12 months are on our website, tullyelderlaw.com, T-U-L-L-Y, elderlaw.com. Under the video tab, there's a click for webinars, all right? You just enter your email, you get the link, and you can watch it as often as you want. It's great foundational all right, information as there's so much going on in the world today. It's nice to have what I think and what I've been told is just clear and concise information on those prior webinars, okay? Another point, the power of attorney itself, it does have limitations and it does need to be modified, all right? Just like the last one, just like all of them. I've been doing this since 1998, and we have always modified our powers of attorney from the statutory form to a new form that we believe is appropriate for our clients, okay? So it'll have powers regarding asset protection and income protection and Medicaid work and trusts, okay? But if there are no modifications, understand if there's no modifications, it's probably insufficient for aging and elder care issues and Medicaid issues, but there is a gifting provision. Currently, it's only $500. So if the gift rider is not currently implemented, the agent can only give $500 a year. Again, the legislature was focusing on fraud and financial abuse. What they've done is increase that to $5,000, probably per year, okay? That's not going to cut it if we're talking asset protection and Medicaid planning. So again, those modifications are important. Another point, oh, and I think you've heard me say this word the most so far over the last 25 minutes, modifications, modifications, modifications. The statutory short form power of attorney is not sufficient in my world. As clients age, as our loved ones are getting older, the idea of long-term care, the idea of paying for long-term care or receiving Medicaid benefits to pay for care in the home or pay for care in a nursing home, if that's needed, that's all in the modifications, okay? And I cannot stress this enough. It's 3 or 4 times a month. I've got a client, a potential client that'll say to me, I know you're talking about a power of attorney, but don't worry, I already have one. Okay, can I see it? Either they have it there in the consultation or they email it to me after the Zoom. Yes, it's a power of attorney, but it's either from the internet or it's from an attorney that doesn't specialize in this area. And if they don't specialize in this area, they're not going to have necessarily the appropriate income protection, asset protection, Medicaid language built into it. A power of attorney is only as good as the words built into it. The agent can only do what it says. And if you need to do something that's not written in there, then you can't do it, okay? And perhaps the power of attorney is insufficient. So if you still have capacity, you get a new updated comprehensive one. If there is no capacity, then what are you looking at? What I mentioned earlier, that idea of a guardianship, okay? So modifications 100% still required. Now, if you are an agent, okay, under the new power of attorney, and this is where we'll be talking about it a little bit, but the clients that have the more recent complicated power of attorney form, do you do the updated one? It's going to be a case-by-case scenario, okay? But record keeping, all right, this is clarified, this is nice. What the new law states is that an agent must, and this is always what we've told clients anyway, and their agents, but an agent must keep a record of all the transactions conducted on behalf of the principal, or keep their receipts, all right, keep their payments. So they have a log tracking everything, or they have the actual receipts, okay? That's common sense. If you're handling somebody else's financials, you need to track everything you're doing. Don't commingle, don't misspend. A power of attorney agent is a fiduciary, okay? They have to act in the principal's best interest. They can't buy themselves the Maserati because they like it with the principal's money, okay? They can't gift to themselves unless it's a part of the plan, okay? So having that clarification and following those fiduciary limits is important, all right? In addition, some clients like to pick 2 agents at a time or 3. We don't like to go that high or even higher because it's too many chefs in the kitchen. But if you do pick more than 1 agent, so let's say you pick your son and your daughter, the current form and the new form will still require the principal to delineate whether that principal wants the agents to act separately or they have to act together. So for example, if I were to pick my son and my daughter as power of attorney agents, I can initial a certain parentheses, a certain box that says they can act separately. If they're both good, trustworthy, responsible kids, then let that happen. All right. That way, if one's out of state on vacation, then the other one can handle it. If one's sick, the other one can handle it. If you don't initial that box, just like now, then they're going to be forced to act together. All right. There was a provision in there dealing with delegation between agents, so that's a good thing. But if the idea is to allow them to act separately, then it should be initialed to keep things as simple as possible. Okay. Another point, and we've seen this happen, and it's a good thing. The appointed agent is now the quote personal representative for healthcare financial matters. Excuse me. This isn't healthcare decision making. That's the healthcare proxy, like we said in the beginning. This is healthcare financial matters. It's talking to the insurance companies. It's talking to the providers about billing, about insurance coverage. So anything regarding healthcare financing and paying for it, now the power of attorney agent has that authority. It was complicated in the past because the power of attorney wouldn't necessarily say it. Ours would, but if it didn't say it, then there's no authority. Now it's just granted, okay? It's in writing that that agent has the authority to deal with the insurance and the billing. A good thing. Another point, and this is where it starts to get good, guys. If a third party, and when I say a third party, that could be a bank, that could be a real estate broker, it could be your Charles Schwab, it could be your financial company, it could be Chase, it could be Bank of America. A third party is somebody other than the principal and the agent. If a third party refuses to honor the power of attorney, okay, not do what the agent asks, they have to put their reasons why. This is brand new and this is huge. So if you take your mother's power of attorney to Chase Bank and they say, we're not going to listen to that, okay? I'm going to make you do our own form, or I'm going to say you got to bring your mom in. Any of those nonsensical things, if that happens, they have 10 days to put those reasons in writing, okay? Again, this is significant. Now, they don't have to just bend over backwards and accept it. They do have they have an avenue of their own, some recourse on their own. They can demand that an agent sign a certification that's probably going to be notarized, an affirmation, if you will, that says the power of attorney principal duly signed this. That principal appointed me, that a principal hasn't revoked this yet, that principal is still alive. So they can make the agent sign something to make them more comfortable. That's fine. In addition, the bank or third party can make them get an opinion letter from an attorney as to, I would imagine, the validity of the power of attorney and the validity of the execution surrounding it. So they do have a little bit of recourse to say, I don't have to bend over backwards and accept every power of attorney. Certify this and get me an attorney opinion letter, okay, as to the validity of the document itself, okay? But again, fantastic big step that they have to put their refusal reasons in writing within 10 days. Now, that doesn't apply to a lot of government entities. It's meant for public, it's meant for the private institutions, the banks and so forth. For example, I read it doesn't apply to Medicaid. Okay, if we have a Medicaid application submitted by a child for a mother with the power of attorney, they can try to reject it later. They're not bound by the 10 days, okay, as an example. Another good point, this is the one that's exciting. If they refuse to honor the power of attorney unreasonably, okay, unreasonably, there are some teeth in this law that will force them to, or at least attempt, we have an avenue to force them to rely on the power of attorney. It's what's called a special proceeding, okay? So if the third party refuses to honor the power of attorney unreasonably, then a special proceeding in the court, it's probably going to be Supreme Court, Nassau, Suffolk, Queens, can be brought to compel the acceptance of the statutory form. It's not the legal Zoom form, it is the statutory form. And this is the teeth. If the special proceeding judge, if the court comes back and says that the third party bank or what have you was wrong, they can make the bank pay damages as well as attorney fees. This is huge, okay? This is the teeth. This is what is very exciting about the new law. Now, the $64,000 question that what we've learned is that prior powers of attorney, and by the way, this has been one of my main concerns for the last, since I first heard this was coming out in December, is are these teeth, is this support that's given to the new powers of attorney also effective to prior powers of attorney? And gratefully, the answer is yes, as long as it was a statutory form, as long as it was executed properly and in accordance with the laws at the time of the execution, okay? So what that means is not everybody in the past that has, I'd say, a power of attorney since 2010 has to update. If you have a power of attorney prior to 2010, yes, you should be updating if you can. So again, the good news is prior powers of attorney, as long as they were executed properly, according to the law implemented at the time on the statutory form, will have this backup, will have these teeth as well, okay? Again, they have to give their reasons why they're rejecting the power of attorney within 10 days in writing. Otherwise, the agent or the principal can bring this special proceeding and go after damages and attorney fees. There's our teeth. Finally, we've complained about this for decades. All right, now, also, to give a little comfort and solace, if you will, to these third parties, if they do honor the power of attorney, they will be held harmless, okay? Meaning that they can't be sued. They can't be held liable because they followed what the power of attorney said. They followed what the agent requested, okay? So if they're doing that in good faith, they will be protected and sheltered, so they can't be sued every turn. Now, this can have negative ramifications. It can mean that the bank is just going to accept every single power of attorney they see because they can't get sued for it, which I don't think it'll necessarily happen, okay? I think they still want to maintain the appropriateness and the propriety of the legitimate statutory power of attorney form. So I'm not that concerned that this is going to be banks run wild with accepting every power of attorney that's out there. Some of my colleagues have said that's a real fear and a slippery slope, and it may be, and time will tell. But again, this is good on their behalf so that they're more willing to work with the powers of attorney and the agents, okay? So there you have it. Those are the main changes that are occurring in 5 weeks, okay? As we've been telling clients that we've been meeting with for the last several months, if we need to get the new power of attorney, we're going to get you back in here and sign the new power of attorney. Those that are hiring us at this point, we're going to be waiting, right, the 5-6 weeks until the new form is out and we make it our own. I think every attorney that does this for a living is going to need some time with the new form, making sure all of the modifications are done properly in the right place, okay? It took about 6 to 8 months with the old form because it was so complicated. But what we're talking about with this new simpler form is we've got one modification section. We know what to put in there. So we should be pretty good to go by the end of June, early July at the latest. Okay. So let me give you a little bit of recap. What happens if there's no power of attorney? Okay. Well, the first question is there capacity? If there is capacity, then you get a new power of attorney. If there is no capacity, then you're going to be forced into a guardianship proceeding, okay? Next point, what happens if the power of attorney is wrong? Meaning you have a form, but there's no modifications, or you have the old form and there's no gift writer. Again, same first question, is there capacity to sign a new one? If so, do it. If there is no capacity to sign a new one, you're back to the guardianship judge, okay? Now, I just added this one today, of course. What happens if you have an old power of attorney? Is it a statutory form? Was it executed properly according to the laws in place at that point in time? Does it have the appropriate modifications? What I'm generally going to say is if you have those 3 things, you should be okay. I'm not saying you are. I'm not saying you don't need to talk to a qualified, experienced elder law attorney like ourselves, but I'm saying you should be okay. If you have an old power of attorney and it's not a statutory form, or it's not executed properly, or if it doesn't have modifications and there's no capacity, that's where you end up again, back in the guardianship, okay? So where do you get this done? Where do you get the proper new form once it's released in June? I just list these because I've had clients get their prior clients. Once we make them clients and they hire us, obviously we're updating them. But do you get the power of attorney form on an online website? No. Do you get it at Staples or Office Depot? No. Do you get it from the attorney closest to your house? No, you don't. Do you get it from the attorney that helped you with the real estate purchase? not unless they're also an elder care or estate planning attorney, because we know what language to build into it, those modifications, okay? So you get the right power of attorney form, the right statutory form, the right modifications at an elder law firm. We are what we call an elder care law firm, which means that we do all the elder law work like all the other ones, but we also focus on the care issues, all right, which is very unique for New York. I have 3 geriatric social workers on staff. We call them care coordinators, and they literally navigate the entire long-term care system for our clients and their caregivers. So our elder law attorneys are joined. We have a team of the attorneys and the advocates, very, very unique. And yes, we can help you with the appropriate power of attorney now and June and July and the future, okay? So how do we do this? Well, basically three different ways. We offer estate planning services for younger folks. We offer elder care protection planning, which is asset protection planning to get that 5-year look back going for those folks that are in their mid-60s or have health issues and are younger. This is typically the irrevocable trust. If you want to know more about that and you're in your mid-60s, call and schedule a consultation, and feel free to check out the webinars online, okay? At tullyelderlaw.com. And then we have what's called life care planning. This is our signature service. This is when there are care needs, when your loved one has been declining. This is where the attorneys and the advocates come together as one united law and care team to help your loved one protect the most assets, get Medicaid to pay, and help them get the best care possible. And of course, the right power of attorney with the right modifications is a part of all of these packages, okay? So thank you very much for joining me today. From this point forward, we're going to be doing weekly webinars. Next Wednesday, however, though, we're doing a private client event. So I'm not doing a public webinar next Wednesday. If you're a client of ours with trusts in place, then you're probably going to be receiving an invite to join that client event next Wednesday. After that, it'll be weekly. We're going to be interviewing folks. We're going to be having an open forum as far as Q&A regarding elder care, planning, and protection. But if you have issues in between those, give us a call, 631-424-2800. Feel free to go to our website, tullyelderlaw.com, or email me, Brian, B-R-I-A-N, at Tully, T-U-L-L-Y, elderlaw.com. So let's see if we have questions, folks. All right. Let's go to the chat box first. Dun, dun, dun. All right. How does a New York power of attorney work in other states? Good question. Occasionally, our clients do move. What we always tell them is where you're going, let us know the county you're going to, and we'll find an attorney in that area for you to sit down with. Have them review your existing planning documents. The power of attorney is very, very state specific. So chances are, if there's capacity, you're going to want to update the power of attorney for whatever state you're going into. You can keep the New York one as well. If you're going to be snowbirding back and forth, you'll have 2, okay? The pitfalls of not having the appropriate power of attorney is the banks in the third parties in those other states not listening to it, okay, not acting upon the power of attorney. How does the person signing on the principals have sign for the principal? Great question, Gene. It's going to be the principal's name, okay, and of course their own name underneath it. I don't know whether it's going to say at the direction of, I don't know whether it's going to say, that's going to be in the statute, and we'll have that answer specifically in several weeks, okay? Oh, thank you, Donald. All right, other questions in the Q&A box. Will the banks accept the new form and not ask for additional forms? Eileen, that is the plan. That is the hope with this new form, that because we have teeth finally, and the ability to bring that special proceeding, and they have the ability to request certifications, and they have the ability to ask for an attorney opinion letter, hopefully that will be all they can ask for, all right? There's a person signing for the principal, sign the principal's name similar to the question before. The answer is going to be yes, but we're going to have, it's going to be similar to how a power of attorney agent signs for somebody at that point anyway. So if Mary Smith appoints Andrew Smith as their agent, Andrew just doesn't sign their name. They just don't sign the mother's name. They'll sign Mary Smith by Andrew Smith, agent, or power of attorney agent, or attorney in fact. So we're going to imagine it's going to be some similar breakdown like that. Does the new power of attorney give the agent the ability to designate powers? What do you mean by designate powers? To designate powers? You mean to I'm not sure, Louis. Let me know what you mean by that, or call me later. If someone did not update an old power of attorney, does the assumption of validity for the new form? Great question, Ron. I don't think it does. I think the presumption of validity is only going to apply to the new form. I haven't seen language. I haven't seen feedback from other colleagues on whether or not that will apply to the old form. Is there able to assist in New Jersey? We are New York attorneys. We can assist with New York clients. We're not able to do work in New Jersey. But just like a client moving there, if you're call the office and give us a county, we could try to find somebody in that county, okay? Does the new law do anything to assure that banks or other institutions accept previous versions? Well, what we're looking at is having the ability, as long as the prior power of attorney was, and Louis, I may have answered this since you typed that, as long as the prior power of attorney was executed on the statutory form, effectively with the appropriate, under the appropriate laws, with the proper procedure, then yes, the ability to have the special proceeding to pursue the teeth should apply to the old powers of attorney. Okay. It should still be 2 witnesses are needed for the power of attorney. Yes, notary as well. So we're still, question about Zoom and virtual signings. We still have the ability through the end of May, they extended every couple of weeks, for virtual document signings, virtual witnessing, virtual notarizing. I think we were just notified yesterday that we're good through the 28th or 29th of May. We'd expect it to be extended again through June. There are strict procedures as far as a virtual signing, showing ID, getting us the forms that were signed that day, okay? So, or at least fax or email copies of them. If a successor is listed on a power of attorney, are they required to sign in order for it to be enforceable? So that is the current form where the agents have to accept responsibility. I haven't seen that on the new form. We'll know more in June when we actually get the tangible form. Given the agent. Okay, designate. Okay, so what we're talking about is, can an agent, what's the word? Can the agent designate somebody else to handle the affairs? It's my understanding that the new law does allow that. In addition, if you have 2 agents working separately, or together, one forced to work together, one can actually allow the other one, designate the other one to be the decision maker solely. So we're going to have more flexibility as far as the 2 agents being able to defer to one. But the idea that you can, just like in the current form, you can have somebody else do it for you, I think, Louis, you're going to run into a practical problem. I haven't seen any, I haven't seen the teeth, if you will, in regard to that specific provision. But if a bank refuses to act on behalf, then the special proceeding option is certainly still going to be available. We'll know more as this rolls out. All right. That is it on the questions. If I didn't answer your question, I apologize. It's because we don't yet know everything. All right. Again, thank you for joining us. I hope to see you at our next, it'll be 2 weeks from today, our next public webinar. All right. Thank you again. Let us know if there's any questions. Bye-bye. Stop our share. We're going to end. All right. Have a good day.